thought you might be interested to hear what the Law Society says about this as of 8th June, obviously after the announcement of the introduction of the new rules from 1st October. They say, we do not support the extension of FRCs in civil litigation under the current proposals, either across the existing fast track or to intermediate cases. We welcome the MOJ's announcement that FRCs for all housing cases will be deferred until at least October 25, but we urge the government to consider scrapping the implementation altogether. So they're not banding their words, the Law Society. They welcome the fact that housing cases have been deferred to October 2025, but they're actually advocating that the whole new FRC regime should be scrapped. They only apply to low value and non-complex claims where the issues are straightforward. The costs are fixed at a reasonable rate to allow for work to be carried out effectively by properly regulated professionals, such as solicitors. There is scope for complex or unusual cases to be exempt. There is strong empirical evidence and research to justify the rates and thresholds that are set initially, and the rates and thresholds are reviewed and adjusted regularly to take account of changing processes and developments in technology. Court procedures and rules are properly aligned to FRC introduction, and lastly, appropriate and efficient IT is introduced in the court system to support the fair and effective delivery of any new fixed cost regime. Well, you won't be surprised to learn the Master Rolls, Sir Geoffrey Voss, says that this new extension is going to be a big change that will take time to bed in. Now, there is some slides here going on to part 47. Now, you're wondering why we got CPR part 47 in a fixed costs webinar. Well, it's because it does raise an interesting principle around white labelling. It does say in the practice direction to part 47 that agency charges as between legal principal, representative and their agents will be dealt with on the principle that such charges, where appropriate, form part of the principal's legal representative's charges. What does that mean? Well, if you instruct an agent to do fee earning work, in other words, work that you would otherwise be doing as a fee earner, you can then charge that work as if you did it yourself. In my very early days as a very young personal injury lawyer, I used to use a retired police officer to obtain some basic witness statements for me and to do plans and photographs of scenes of road traffic collisions. And he would charge me £50 an hour, not registered for VAT. And I used to then charge that work as if I did it myself, put it in the bill of cost when I was successful, and recover my rate at the time, which was £125 an hour.